Good morning, good evening, everyone. Welcome to CAM-CCBC's webinar, So Close, Yet So Far, What's New in Asian-Latam American Proceedings. My name is Ana Flávia Furtado, and I am CAM-CCBC's Institutional Development Advisor. But before we start, I would like to take this brief moment to share some CAM-CCBC's numbers and most recent experiences. The fact that the pandemic imposed many obstacles on pretty much every aspect of our lives is no longer news, and hopefully we seem to be reaching its final stages. That is why CAM-CCBC will soon publish the CAM-CCBC 2020-2021 Facts and Figures, a publication of data from this very unique time. Contrary to what would be expected, after the outbreak of the pandemic, the number of proceedings initiated at CAM-CCBC registered an increase of 8% in 2020 and 23% in 2021. Last year, CAM-CCBC received a total of 128 arbitration proceedings, the second highest number of arbitration proceedings initiated in a single year in CAM-CCBC since its foundations in 1979. In CAM-CCBC's Facts and Figures publication, we will also see that in the last 2 years, we have been experiencing arbitral proceedings featuring Asian parties, especially from China mainland and Singapore. This is why we chose to invite a team of experts to discuss the new trends in Asian-Latam proceedings. And since CAM-CCBC is a huge supporter of moot court competitions, what a better time to host this webinar than now during the Vis East Moot week. Today, we are going to hear from people from Brazil and abroad who had experience in dealing with Asian Latin American proceedings. For example, Luiz Peretti, partner at Souto Correia Advogados, Sherlin Tung, partner at Wither Worldwide, based in Hong Kong, Luiz Vidal, foreign counsel at the Hague Law Office, based in Beijing, Bernard Poch, partner at Batista Martins Advogados, and also a new gen, our CAM-CCBC Youth Commission Sterling Committee member, Vanya Wączowski, senior partner at Wączowski Clayman Advogados, and all of these experts will be moderated by our Deputy Secretary General, Luíza Kömel. Despite the strong economic bonds between Latin American and Asian countries, in fact, we are in two different hemispheres. So we are very excited to hear from our team of speakers, our team of experts on this new trend in arbitration. Last but not least, I would like to thank our very much appreciated support of the Chartered Institute of Arbitrators, our Brazil branch, represented here today by Cesar Pereira, who I'll now invite to speak a few words for us before we start the webinar. Thank you very much.
Thank you, Ana Flávia. It's a pleasure and an honor to be here on behalf of the Chartered Institute of Arbitrators to express our support to this new initiative of CAM-CCBC, which is very much in line with everything that CIArb represents. It's our true belief that CIArb and CAM-CCBC can be indeed platforms that can bring Asian parties and Latin American parties together and in an opportunity to learn how to improve and how to further develop a dispute resolution between these two hemispheres, as you said. It's also for me personally a moment of joy to be with all of you here, because in a way I have either met some of you at Vis East or spent a great deal of time with you in several editions of Vis East. And so although we cannot be there in Hong Kong this time because of everything that you mentioned, it's always good to be here virtually with you and remember some of the good times in Hong Kong and look forward to the next editions after this is all over. I would just like to highlight that some of the obvious points of connection between Asian parties and Brazilian parties or Latin American parties are related to the sale of goods, commodities, the supply of industrialized goods, all those things that are in a way subject to, or may be subject to the application of the CISG as a common body of rules. And that is a very important aspect of dispute resolution between Asian and Latin American parties. But on the other hand, there are many examples of Asian investment in Brazil, like long-term investment in Brazil. And it's important to highlight, and I'm sure we will discuss this later, that Brazil is not a party to BITs, to investment protection treaties. And therefore, parties that invest in Brazil rely on contract-based commercial arbitration. And that is true for construction investments, that is true for energy, that is true for many areas, many industries in which Asian companies are now in Brazil. And that is why I think it's so important for us to discuss all the issues that we're going to discuss here today, because parties must be aware of the peculiarities of the important aspects of commercial contract-based arbitration in Brazil when dealing with the protection of their investments. So without taking any more time from our speakers, thank you very much again, Ana Flavia and Luíza and everyone at CAM-CCBC for, again, this new opportunity to collaborate with the Chartered Institute. And I wish we all very enlightening and interesting discussion today. Thank you.
Thank you, Cesar. Good morning or good evening, everyone. My name is Luíza Kömel, Deputy Secretary General at the CAM-CCBC, which is the Center for Arbitration and Mediation of the Chamber of Commerce, Brasil-Canadá. And I'm very honored to be here today. Thank you to our dear speakers and to everyone watching. We've noticed that after 2 years of virtual events, we get a lot more people watching these types of events afterwards rather than live. So thank you as well. Special thanks to Cesar and the Brazilian branch of the Chartered Institute of Arbitrators for the cooperation. And it is a pleasure for all of us to be here participating in the Vis East week. Thank you, Sherlin, for taking your time to be here with us today, even though we know this is a crazy, crazy week. Well, for more than a decade, the CAM-CCBC has been sponsoring teams, organizing pre-moots in São Paulo and Hamburg, and supporting the Vis Moot competition. We started supporting the Vis East more recently, but it's extremely rewarding to see the positive results and the positive impact that the Hong Kong competition already has had on our students. And in terms of the CAM-CCBC, just to give you an idea, the CAM-CCBC was recognized as the only leading arbitral institution here in Brazil by Leaders League 2022, and the 8th worldwide top-of-mind institution in the famous 2018 International Arbitration Survey conducted by Queen Mary University of London and White & Case. The center was founded 43 years ago. We're currently revising our arbitration rules, which have been around for 10 years. And I can proudly share that we are the most traditional arbitration institution in the country. We are responsible for administering close to 50% of the Brazilian market of complex arbitration proceedings. On top of that, we are an international institution. That's why we're here today. In 2020, out of the arbitration proceedings initiated at the CAM-CCBC, 20% of the disputes involve foreign parties. We currently have offices in São Paulo and Rio de Janeiro, but what is most important is that we are able to administer proceedings anywhere in the world. So especially now after the pandemic, when we noticed that files related to arbitration cases, which were still being done through the exchange of physical documents, were all successfully replaced with electronic communication. So this represented an impressive reduction in costs as well as an environmental aspect. On that note, we are proud to say that at the CAM-CCBC, we're carbon zero, and we have signed the Green Pledge. But what we're discussing today is what is new in Asian and Latin American arbitration proceedings. According to the 2021 Queen Mary Arbitration Survey, Singapore, Hong Kong, Beijing, and Shanghai were present in the top 10 of the most preferred seats for international arbitration. This is a trend that has been also noticed in arbitration institutions. So in terms of arbitration the institutional preference, Asian institutions such as the CIAC, the HKIAC, and CIATAC also ranked among the top 5 preferred arbitral institutions worldwide. However, if we look into the percentages in Latin America, in the same 2021 Queen Mary's International Arbitration Survey, we see that the preferred seats in the region are Paris, in the region of Latin America, I mean, are Paris, New York, and only in third, Sao Paulo. So if we examine the Asian-Latin American economic relations, there's an undeniable potential for cooperation there. Very recently, in December, China and Latin American countries have signed an agreement to enhance economic cooperation, including trade and investment. The deal, which was titled Joint Action for Cooperation in Key Areas, sets out a wide-ranging agreement to cooperate politically, economically, and socially through trade, investment, innovation, energy, communications, and development. So how can we perceive all of these results, the economic relations between Asian and Latin American parties being translated into choosing dispute resolution methods seated in Asia and Latin America, or being administered by Asian and Latin American institutions? This is what I personally would like to know the answer to. But in order to get there, in order to bridge the gap between these two worlds, as the title says, so close and yet so far, let us move on to the topics and the discussions of the speakers we have here today. We have 5 main topics we intend to cover, but please send us your questions here through the chat function, and we will just present them to the speakers. Let me start off with Bernard. So from your experience, has there been an increase in breaches of contract in the last few years? We've seen signs towards the nationalization of the production chain in some countries. Did you experience this in practice, and what are the impacts on contracts and arbitration proceedings?
First of all, thank you, Luíza, for the question, and also for the invite here. It's a pleasure to cooperate with CAM-CCBC, be on this webinar or through the new GEM CAM-CCBC, which I invite all of you to join us. As to breaches of contracts, yes, I have seen an increase on the last few years, particularly relating to the effects of the pandemic. And this increase, the type of dispute that saw an increase, came somewhat in waves, at least for us here at the office. First, at the beginning of the pandemic, we saw the disputes relating to the effects of the lockdown, and this impacted particularly contracts for the sale of energy. We had a fair number of disputes in 2020, beginning in 2020, and in the beginning of 2021 also, relating to parties that, due to the lockdown measures adopted, tried to renegotiate, and if they were not able to, it began litigation, or more specific arbitration related to their contracts for the sale of energy. Just a curiosity, here in Brazil, when we are dealing with contracts for the sale of energy, all parties are mandated to go to arbitration. They are mandated to sign an arbitration agreement in order to take part in this market. So we saw a fair number, I believe in 3 months in 2010, I believe the number of the disputes related to the sale of the energy spiked 200–300% in 3 months, to the point that the entity here in Brazil that is responsible for registering, keeping track of all the energy trade deals, felt the need to send a letter to all tribunals involved in those cases to inform it could act as amicus curiae should they need to obtain data or better understand how the system worked. Afterwards, we had somewhat of a second wave, for disputes that were indirectly impacted by the pandemic. For instance, we have seen cases where share purchase agreements were signed just prior to the pandemic, and some of the clauses relating to the adjustment in price were impacted by the fact that receivables were delayed. We also had some disputes relating to the fact that, particularly here in Brazil, but now around the world, we saw a spike on inflation, and this who should bear the cost of this inflation in long-term contracts. So 2020 and 2021 have seen an increase, a fairly big increase to breaches of contract, as also shown by the statistics mentioned by CAM-CCBC. As to the second question, to be quite frank, I have not experienced a nationalization trend in practice. This may mean that the trend has not reached the jurisdictions where I mainly act, that means mainly Latin America, or maybe that there are problems resulting from it are still brewing. Nationalization is not a short-term measure. It takes some time to take effect. So maybe we will see it in the coming years, but at least speaking about Brazil, it seems to me that maybe we do not have this trend here in our market. These are my comments on this first question. Thank you very much.
Thanks, Bernard. Now let's move on to Sherlin. What do you have to say to us?
So I have to first apologize. I'm in the Vis East Administration office, which is in a great building in Hong Kong, but the first floor. And even with it being in a pandemic, there's still so much noise in the back. So it's not that I'm just in this middle of a party town. It is just Hong Kong. Second, again, thank you guys for the invitation. It is always a pleasure, even though Luíza and Cesar have made my life a little bit more difficult this week, and they know why, but I still love them. Turning to the question, though, I will say one thing that we have seen a rise of due to the COVID pandemic, and in particular with clients that have operations in Asia and also Brazil, is breaches of contracts in relation to medical supplies, medical gloves, surgical masks, anything else that's PPE related, etc. China is one of the world's largest manufacturers of these products, as is Malaysia and Thailand. And that's one of, fortunate for my clients, I guess, that's one of our specialties in that they do a lot of medical rubber gloves or surgical masks. But I've also seen a number of other who are distributors in Brazil or even in the West. And they've entered into what they believe were amazing contracts when they executed the contract with set pricing, fixed pricing. But most of these manufacturers in Asia have been able to declare force majeure, or just due to the supply and demand have been able to hold something over these distributors and constantly raise the price. So a lot of these breach of contracts that we've seen have involved various issues, including transfer pricing for rubber or other raw materials used to make such products, or even breaches in price fixing. So that's been quite an interesting field. We continue to see it. Even though the pandemic is yet to be over, we now are seeing it turn in the other direction, because now the distributors, for example, in Brazil, have a stronger case. They've got the stronger side now, right? Because they no longer need the gloves or need the masks as much as they did before. And now all of these strict revision of contracts that they've entered into with their manufacturers, tables have turned. And so now the manufacturers are asking us for legal assessments as to what can they do. You know, they had initial framework in the beginning, 5-10 years ago, that discussed a fixed price or a specific formula on how they would come to volume and price. Then halfway in between or halfway through these contracts, COVID hit, and the manufacturers were able to turn the tables on the distributors where they had to do these amendments, and they used force majeure. And now it's the other way around again, with the distributors now declaring, oh, it's the other way around. We no longer need it. The situation is no longer the same. We're not going to pay all of the pricing that you've demanded. So it's quite an interesting topic for us. That I think has been the biggest thing. Unfortunately, while we've seen a number of disputes, we haven't really been able to kick off as many arbitrations or even litigations because the parties, no matter what, in the pandemic times, they're very hesitant to pull the trigger. So the firm, we've done a lot of legal assessments. So I can tell you, if anybody needs a legal assessment on certain topics, we probably have one that we can pull out for you. But that's been very interesting. As to whether or not we've seen more nationalization of the production, we have, and I'm sure you guys are all familiar, at least in China. China, I think in 2000, end of 2020, early 2021, implemented a new regulatory system for a number of their medical devices on how certain limitations and requirements of what needs to be met in order to export. In the past, I mean, China's always had a specific standard, but the manufacturers have always been forced to meet the standards of the West, right? Whether it's ISO standards or the various standards of where they're shipping into. But last year or a year and a half ago, we saw a change where China had implemented their own regulatory measures where any masks, gloves, whatever produced had to meet that particular standard. And it didn't necessarily stick with the standards of their end users. So we saw a lot of resulting assessments from that as well, because the problem is most of these types of contracts require specific regulatory measures. But now that China and other, for example, we've seen Malaysia do a similar thing, has implemented their own national standards, things needed to be revised. And the question was whether or not additional costs had to be incurred by the distributor in order for the manufacturer to meet the necessary requirements. I feel like that was answered the question, and if not, just blame the back.
That's very interesting, Sherlin, very well connected to the pandemic in general. But now moving on to Luiz Peretti. Do you have anything to share on this topic of the breaches of contract?
First of all, thank you, Luíza, and thank CAM-CCBC and CIArb for hosting this event. It's a pleasure to participate, and it's also a pleasure to, especially because it is hosted by CAM-CCBC, an institution that has already done a lot in what you were mentioning earlier in trying to bridge the gap between Asian and Latin American parties. I remember in 2017, when CAM-CCBC rules were adopted in the Vis East Moot in Vienna and Hong Kong. And that was certainly to trust Latin America as a seat of arbitration, and also allowing the parties to choose different seats of arbitration rather than the traditional ones that you were mentioning. So moving to this topic, in my perspective in Brazil, we had a very evident difference between the contracts that were entered into in the context of international trade. Those contracts were contracts in which, as Bernard said earlier, there was an initiative to renegotiate, and that were solved in many cases by negotiation, because it was the SARS-CoV pandemic was such a clear force majeure event. But what we have seen in Brazil is actually the trickle-down effect of problems affecting logistics, the supply chain, not particularly on the international contracts, but in the domestic contracts that were relying on inputs from the international trade. For instance, in EPC contracts that were expecting to receive solar panels or other types of materials from abroad, those were the contracts that were mainly affected. And basically, since those were domestic contracts that did not initially consider the potential effects of international trade, maybe those were contracts in which the parties did not see it coming, and that there was no risk allocation for potential disruptions to the international trade. So we did see a lot of breaches of contract, but those were mainly in the domestic contracts, since the international ones have been resolved through negotiations and through amicable settlement. we did see a huge impact in the foreign investment in Brazil. Cesar was telling us earlier that Brazil is not party to BIT treaties, and it's not party to the ICSID convention, so that arbitration plays a role in allowing certainty and security for foreign investors in Brazil. And what happens then is that in 2020 and 2021, there was a steep reduction in foreign investment. We have seen globally a reduction of 35% in FDI, but in Brazil, we contracted for 61% of foreign direct investment. So that takes a huge toll on Chinese investments in Brazil or Asian investments in Brazil, since most of those investments are not made by trade, or most of the economic relationships between Asia and Brazil are not organized by trade or by contracts, but rather by direct investment with a more looking for a long-term relationship. So we did have a big impact of SARS-CoV in Brazil with business relating to Asia, but mostly in connection with FDI. And finally, just a brief word regarding this trend towards the nationalization of the production chain. Since we have in Brazil a long history of trying to substitute imports that hasn't played out well, and I don't see it coming in the next years. I think that Brazil is surfing the tide of commodities whose prices are getting higher and higher, and I don't think we will enact any kinds of protectionist policies or change that stance in the future. So that was all for the first topic.
Thank you, Peretti. So now moving away a little bit from the merits of the discussions and from the business sectors which were impacted by the pandemic, let us discuss now arbitration a little bit. And back to you, Peretti. Peretti, what would you say are the main requirements of the parties, so both Latin American parties and Asian parties, when signing an arbitration clause? And last, did the pandemic alter these requirements?
Right, Luíza. So the main requirement for my clients and for Asian and Latin American parties doing business together is to choose a dispute resolution mechanism that is effective, that will yield an enforceable solution. And that is important in two aspects. First of all, you need a enforceable agreement to arbitrate, which is a prior step in this, in adopting arbitration as a way to resolve disputes. You need an enforceable agreement to arbitrate, because this is what will prevent local courts from meddling in the disputes and hearing and judging those cases. And in order to achieve that, the parties could always, of course, look at the 169 signatory parties to the New York Convention, but of course they will not, it's simply impossible to look at all those jurisdictions. So they'll have to look into the Asian and the Latin American jurisdictions that are relevant to the contract, or mainly the jurisdictions in which the parties have assets and that may be selected to enforce the arbitral award. In most Latin American jurisdictions, we have arbitration laws compatible with the UNCITRAL model law. So there's not much of a mystery as to what you need in order to have an enforceable agreement to arbitrate. And there's a trend towards modernizing those rules. In 2018, maybe the latest positive news that we had in Latin America is that Argentina and Uruguay in the same month enacted new international commercial arbitration laws that are compatible with the New York Convention. But even if we have modern legislations, there are still some particular points to consider. So the Lex Arbitri, all those countries may enact other requirements that must be taken under account to organize the arbitration. For instance, and this is something that Vidal may mention later on, China does not admit ad hoc arbitration. There is a new bill under consideration, but that as of today, you need an institution to administer the proceeding. And on the other hand, Brazilian law, for instance, requires contracts that are entered into by adhesion to have a specific signature so that they can be considered valid. You can remember, for instance, the insurance industry has had some important cases recently that discusses what is necessary in order to make an agreement to arbitrate valid in Latin America. So this is something to consider if you want an enforceable agreement to arbitrate, and this is a basic requirement so that you can have a enforceable arbitration and an effective proceeding. So turning to the second point, what has changed after the pandemic? Well, the main point that has changed in the execution of contracts, of agreements to arbitrate, is that we used to have meetings in order to enter into contracts and agreements to arbitrate. So most of the contracts use wet signatures. Parties were present and executed those contracts. And basically, this is why the arbitration clause was dubbed the champagne clause, because it is an agreement normally executed in person and at the end of a negotiation. So the pandemic forced us to use technologies that were available before the pandemic that were not used. I can still recall in my first arbitrations after the pandemic that the arbitrators were considering how they would sign the award. Would it be sufficient to cut and paste their signature and to include in the award? What would be the mechanisms that should be adopted so that you would have an enforceable agreement to arbitrate and then an arbitration award? And this is something that we have become more proficient at. Arbitrators and parties have now a better understanding of what is necessary in each jurisdiction so that you can have a valid electronic agreement to arbitrate. So I'll conclude with just one remark. Another requirement so that users of arbitration in Latin America and in Asia must heed in order to have a successful experience in arbitrating is the choice of an adequate arbitration institution. In international arbitration, parties will be very aware of the neutrality of the process. They'll try to avoid local courts so that they can rely on arbitration. And nowadays, we do have a good choice of arbitral institutions that may play this role in Latin America and in Asia as well. For instance, for disputes involving foreign parties in Brazil, CAM-CCBC is being accepted with no problem. And we have also Brazilian clients arbitrating in CTEC in China, the HKIAC in Hong Kong, CCI or CIAC in Singapore. And those institutions will normally provide model clauses referencing a set of rules that will make adaptations, will adapt the agreement in all terms necessary so that you'll have an enforceable arbitration. I will not go into the enforcement of the arbitration award, since this will be discussed in the next topic. So those would be the main requirements to heed if you want a valid arbitration, and the main concerns that Asian and Latin American parties have presented in my experience, and they sum up as to having an effective solution and choosing arbitration in a way that it will be not challenged by courts and then accepted and respected once the arbitral award is rendered.
Thank you, Peretti. Vanya, what have you noticed with regards to Latin American and Asian parties specifics when signing an arbitration clause?
Well, first of all, good morning or good evening, everyone, depending on which part of the world you are now. I would like to thank CAM-CCBC, Luíza Kömel for the invitation to be here today. Thanks, CIArb as well. Well, additionally to the comments made by Luiz Peretti, to which I completely agree, I would like to talk a little bit about some points that are always discussed by parties in the negotiation of an arbitration clause. And I can give you some examples based on a recent experience I've had in the negotiation of an arbitration clause in a very complex supply and service agreement between a Chinese and a Brazilian company in the context of an EPC contract for a solar plant. This case was interesting because that expression that says that the arbitration clause is the midnight clause was totally applicable here. It was the last provision to be reviewed by both councils that has less time to discuss it, and parties were putting too much pressure to sign the agreement as soon as possible. They have already overcome several commercial and legal issues, and they did not want to, discuss deeply the arbitration clause. Well, the main points of discussions in this specific case, in which with my experience, I can say that are always point of discussions in the negotiation of arbitration clauses are, or were in this case. First of all, the seat of arbitration. I'm not going to talk a lot about seat of arbitration here because we are going to discuss this issue in another topic here today. But this is a main point that is also a point of discussion. And in this case, I'm mentioning here, the products would be delivered in Brazil, the services would be rendered in Brazil. The Brazilian company wanted the seat of arbitration to be São Paulo, but the Chinese company did not want to use São Paulo as the seat of arbitration, and neither to use the administration of a Brazilian arbitration institution. They wanted to use a neutral seat and a global recognized arbitration institution. Well, both parties discussed and they finally set an agreement, reached an agreement. They decided to use Paris as the seat, and the arbitration would be conducted before the ICC and its rules. They chose Paris because in their thought, it was like middle way between the countries. And although I told them that we could have hearings or meetings elsewhere in the world, they decided to choose Paris for this reason. And what I noticed in this case is that the Chinese company was concerned about having to use the lower courts in Brazil in case of any dispute, or to use Brazilian law as the law of the seat. Well, another point of discussion was the language. Both parties agreed to use English as the language of the arbitral proceedings, but the Brazilian company was concerned about the production of evidence in case of a dispute. The contract involved, among other things, as I mentioned, the construction of a solar plant in Brazil. So the most relevant documents would be produced in Portuguese. And the Brazilian company was concerned about the cost of translation and also about the difficulty in producing evidence in English. For that reason, the arbitration clause contained a provision stating that the parties would be allowed to produce evidence either in English or in Portuguese without any requirement of translation. This situation brings a limitation on the profile of the possible arbitrators. Arbitrators in this case must be proficient in both languages, English or Portuguese. Otherwise, translation and interpretation might be necessary, which would increase the cost of the proceeding. And that was exactly what parties wanted to avoid. Confidentiality is also an issue pretty much discussed in arbitration clauses. In this case here, this was an important issue for both parties. It was essential for them, since the agreement and its execution could reveal a lot of confidential and sensible information of both parties' business, and they wanted to avoid public disclosure of trade secrets, technical information, and so on. There is another point, which is always a point of attention for Brazilian parties and also to foreign parties doing business with Brazilian parties, which is the allocation of costs and expenses. In this specific case, both parties agreed that the ordinary costs, the administrative fees and arbitrators' compensations should be borne by the losing party, except attorney's fees agreed between a party and its counsels, which should be borne by the respective party. So both parties expressly excluded contractual attorney's fees of the amounts to be reimbursed, since they understood that those amounts were unpredictable. But the interesting point here, which is very contradictory to everything I just said, is that the counsel of one of the parties suggested to include a clause in this arbitration agreement, stating that, I will read it. The arbitration tribunal shall be entitled to order the losing party in the arbitration to pay attorney's fees to the other party's counsel in amounts reasonably determined by the arbitral tribunal. In other words, the defeated party will have to pay attorney's fees to the counsel of the winning party. It's what we call in Brazil succumbence fees. I don't know if it's a well-known term, but are a peculiarity of the Brazilian legal system. And it's a point of attention for foreign parties when negotiating arbitration clauses with Brazilian entities. And it's always a point of intense discussion among parties and counsels. Well, finally, there was also a discussion regarding virtual meetings and virtual proceedings. So additionally to what Luiz Peretti just said, this was the main change regarding COVID pandemic that I noticed in regards to the arbitration clause. So the parties were concerned about including the possibility of hearings to be held remotely and correspondence submissions to be exchanged remotely as well. But in this case, and I noticed this in other cases I've been negotiating as well, that parties wish to have the opportunity to have in-person hearings if sanitary conditions allow them to happen. So I see that parties recognize the benefit from virtual hearings in terms of cost, in terms of efficiency of the proceedings, but sometimes they want to maintain the possibility of having in-person meetings in the future. So these were my comments. Thank you so much for your attention.
Thank you, Vanya. And now, since he's a Brazilian that is currently based in China, who better than Luiz Vidal to answer this next question? So Paul Mason brought up an interesting aspect in the chat regarding the appropriate legal seat. So Luiz, Vidal, besides these Latin American and Asian party specifics when signing an arbitration clause, what does an Asian party value in terms of an arbitration framework? So is that arbitration law, seat, enforcement, New York Convention, time zone? What do you have to share to us in that regard?
Thanks, Luísa. First of all, thank you for the invitation. It's a pleasure for me to share the floor here with such dear colleagues, friends, and to discuss such important topics, since Asia and Latin America has been dealing and transacting quite intensively in the past years, especially then between China and Brazil and some other Latin American countries. So I think the task here is it's quite fruitful for the debate and to understand the concerns between each side. So I guess Asian parties, when we enter in a transaction, especially I can speak about Chinese ones, it's not uncommon to see them asking for the arbitration to be seated in China, or to under Chinese law and applicable language being in Chinese, right? Of course, the acceptance of these terms depends a lot of the leverage that one party holds on the negotiation for such terms to be defined. Nevertheless, I think in more simple transactions involving some not so complex supply agreements, as Vanya has shared with us previously, or more standard contracts for maybe some inputs acquisition that are not so strategic to the company, or to be placed in the local industry. Then I think we have like a really increase in these clauses to be chosen, like Chinese law, to arbitration to be held in China. And because mainly involve international trade, and therefore, like because of the conditions of payment, also applies more a little risk for kind of a breach, because often is used as like true letter of credit, like local inspections here in China by certified companies. So all these granted, and of course, like all the shipment of the inputs are insured. So these offer kind of a securities maybe for the Brazilian side to have more acceptance of holding these kind of contracts under CIArb and the Chinese law. Nevertheless, disputes, I mean, aside from big infrastructure projects, especially like really complex EPCs, which normally the seat tends to be where the project is actually located. Chinese companies tends to prefer not local seats in the other parties' countries, right? So and tends to prefer East Asian seats like Hong Kong as one example, and Singapore, which has been growing quite a lot in the past years as another alternative. And for that matter, I guess this involves also with like more cultural background, I think, which we will be basically speaking further today. But it's more within the time zone. It's easier for them to allocate it rather than to have dispatch a team or hire lawyers in other jurisdictions that they're not much familiar with. So and now talking a little bit about the next topic, like the enforcement of the award itself. What's main concern of Chinese, I guess, if we understand a little bit how it works in the enforcement in China, within China, we understand their concerns also to have the awards enforced abroad. So by this sense, I'm going to focus a little bit how it works in China. I think can enlighten a lot on the mindset for the decision, since also like the enforceability and other topics was already pretty much debated and enlightened by Vanya and also Peretti. So here in China, China adopted like the New York Convention, so it's really rare to see international arbitration awards not being enforced in China, and therefore against Chinese companies. China, nevertheless, has like a special recognition procedure of the award before the enforcement in the court, in the local court. So in China, here we start this enforcement procedure at the high court level, but this is like an internal procedure of the court. The parties doesn't have any access, the lawyers doesn't have any access to this recognition phase. So if, for example, is not conflicted with any possibilities or hypothesis of the Article 5 of New York Convention, then there is automatically like review from the Supreme People Court, which is the final entity who can grant or refuse the enforcement or the recognition of international award in China. Also, Chinese arbitration law, there is a difference between what is domestic, foreign related, and international arbitration awards. And basically, this difference means that if it's a pure domestic arbitration award, the court actually has the powers to review the merits of the case, the facts, and actually overruled. It's a new merit judgment, not an enforcement itself. It at least could be. In terms of the international or international related means that some like assets or one of the parties outside, but the arbitration was conducted in China. Then there is a lot of examples that China recognized these awards and enforced it quite successfully. Here we have like many cases of foreign companies applying here to enforce and being able to succeed in court. One of the trickiest things, though, that I think this kind of a blur is like becomes behind the mind when enforcing outside as well. Here in China, we have like, for example, 2 recent cases in our firm, which kind of spooked a little bit our assessment of the case, right? First one was like an award that was issued by ICC in Paris. And for us to be able to enforce this arbitration or to start the recognition procedure of this arbitration award, in China, we have to legalize this document. And the Chinese embassy or the Chinese consulate locally, when you do the legalization, they ask some questions like what for you are asking, you are applying for this legalization, what the document's going to be used for, etc. But normally, this is questions that are asked to the party to reply, and for the consulate or the embassy just to take records of this. But in this case, they asked like ICC to reply these questions, which was kind of surprising for us. But the client like managed to ask for the help of ICC on this. So the case is actually moving forward, but this was actually some barriers that we haven't seen ever before, and that actually might be compromising the enforcement itself of the award, and it was caused by a Chinese diplomatic institution, right? The second case, it was a more like trickier one. It was an enforcement of an arbitration award against a party in Shandong province. And while the arbitration was like recognized and it was started the enforcement itself, the other parties made a criminal claim in the police station involving the case, which was kind of a fuzzy one, but still possible to be investigated. But the court itself decided to suspend the enforcement of the arbitration award until the criminal investigation is concluded. So which means like the award itself is being suspended, and the enforcement of the award is being suspended for like several years from now. I think it was about 3 years that we are following up this case, and it's still the investigation is it's going on, and the enforcement itself is stopped. So I guess these kind of problems keeps like shedding in the back mind of the Chinese parties when having to decide where to enforce the arbitration award. I think basically is this what we have been seeing so far from this side. Thank you.
Thank you, Luiz. Sherlin, do you have anything to say on this?
It all sounds exactly what we've been through. I will say China has a reputation for allegedly not really enforcing international arbitration awards. You hear clients all the time worried about having to have an arbitration that's seated in China. And so therefore, by default, the clients often end up bringing to Hong Kong, although quite honestly, lately, we've gotten a number of queries of whether Singapore is more preferred over Hong Kong. Here's where I'm going to use my sales pitch for Hong Kong, which is beneficial to all parties, including Brazilian parties. If you do continue to do business with mainland Chinese entities, and as we see, and as we will continue to see, the business between Brazil and Asia, and particularly China, I believe will only continue to grow. You can't necessarily completely ignore this large economy. The best seat of arbitration, if you do believe that China is still not neutral, would be Hong Kong, because of the various mutual arrangements that exist between Hong Kong and mainland China. These mutual arrangements include the enforcement of awards, the interim measures. Recently, even for litigation matters, we have mutual arrangements. I know just about a couple months ago, the mutual arrangement on judgments on family litigations passed. And before that, you've got the mutual arrangements for enforcement of court judgments. So I guess that was my pitch of Hong Kong, but just to be real, it really is preferable, because if you go to another seat in Asia, such as Singapore, you don't have the same benefits. And as one of the biggest worries of clients is how can a client, once they win that award, how do they actually get the money? And we recently had a case, actually a Brazilian party was in an HKIC arbitration against a Chinese company. And they had this award that was about, I think, 2 years old. And at that point, they didn't know what to do, because they weren't too sure how they could sue the company in China, because that company no longer existed. And I know Cesar had put it in the chat. It's piercing the corporate veil has always been very difficult. And I'm not saying that it's easy in China. In fact, it's really not, because China has the same ideas behind the corporate structures as the world does, right? Companies will enter into various legal entities in order to protect certain assets. But at the same time, I am a full believer in that China has faith in its commercial reputation. The Chinese courts, the Chinese government, they want to see their economy grow. And they will see, for example, we had a client, this client went into China to try to enforce an award against the company that no longer existed. Surprisingly, we've gotten over the first hump. We've been able to now commence proceedings against the parent company. And there were a lot less hoops than we thought. It wasn't easy, there were hoops, but it was nothing different from what you would see in Brazil, in the US, in Europe. So those would be my 2 cents.
Thanks, Sherlin. So now to everyone watching, let me just go ahead and read Cesar Pereira's question and move to Luiz Peretti to comment on. So Cesar Pereira stated, an issue that often comes up in practice is how to enforce an award. Many times the party entering the contract is a special purpose company that may not have assets to honor the award. An obvious way to deal with this is think ahead and include the necessary bonds or guarantees, including parent company guarantees in the contract. However, when the potential creditor has not been so careful at the time of conclusion of the contract and is later faced with this difficulty, do you see any way around the situation? Is there a trend to accept or not the disregard of corporate veil to reach affiliates that may have the required assets to honor the award? The prospective effectiveness of enforcement is a key aspect that parties consider when contemplating possible arbitration or litigation, in my experience. So, Luiz Peretti, what do you have to say?
Thank you, Luíza. First of all, the question bears Cesar's signature because it evidently comes from a experienced and careful lawyer who's considering all those enforcement implications. So I'd like to say a few things about this and also echo what Sherlin was mentioning about China. So starting with this idea of piercing the corporate veil and trying to get to assets belonging to a parent company that wasn't originally included in the contract, bearing the agreement to arbitrate, possibly not in the arbitration proceeding, and then, of course, similarly not in the arbitral award. It's interesting to hear Sherlin's perspective from China to see that there are strict rules applicable, but that there have been some positive cases. In Brazil, I think that the situation should be analyzed in 2 perspectives. First of all, during the arbitration proceeding. So let's consider this question. We have seen that the respondent is an empty shell. The party that is seeking a remedy in arbitration can already foresee that even though it may get a positive award, at the end it won't be enforced. So it's now looking into what other companies can be held liable for this award and have to answer with their assets. During the arbitration proceeding, Brazilian commentators, and I'll not quote them because that doesn't, we are not in an academic event, we are discussing with practitioners, but the main opinion among scholars is that the arbitrators, they do not have enough powers in order to pierce the corporate veil and to reach to other parties that have not executed, that have not consented to arbitration. Of course, we are amongst specialists, so we all know that there are alternatives to the written consent to arbitration. In Brazilian law, we may consider, for instance, the consent by conduct and other ways of consenting to arbitration. But as a general rule, arbitrators do not and should not extend the reach of the arbitration agreement to parties that have not consented either in the contract or later through conduct. So commentators normally, they criticize and they hold that the arbitrators lack powers in order to reach to other parties. But then this can be attempted at the enforcement stage. If you have an arbitral award, you can always ask the local courts to try and extend the effects of that award to other parties. Of course, you'll face a very narrow door that is Article 50 of the Brazilian Civil Code, most of all because in 2018 we had a new rule that is called the Freedom of Initiative Act that narrowed down a little bit more that possibility, and you can only enforce to other parties if you can prove, for instance, that there was fraud, that the assets of those companies were mingled together. So this is why I complimented Cesar's question at the beginning, because it also had the answer. I think that the party who needs to pierce the corporate veil in Brazil will be in a bind, and then it would be much better off if they had foreseen this in advance, as Cesar suggested, and included a parent company guarantee, a guarantor, or a bond, any other way of trying to expressly reach to the assets of that company. And then just a quick comment, I definitely agree with what Sherlin was saying about the advantages of arbitrating in Hong Kong. We can see many reports of positive cases using that arrangement concerning mutual enforcement of arbitral awards. There are also good news regarding the enforcement of interim measures that are dictated in Hong Kong and then enforced in the mainland China. So this is certainly an important advantage. But then I'll finish by agreeing also with Luiz Vidal when he mentioned that, and Sherlin also mentioned this, that China is trying to present itself to foreign investors as a fair commercial venue. I was in 2018 in Beijing for the China Arbitration Week, and I was in a panel with a lady from the Supreme People's Court, and I was impressed because we were celebrating 60 years of the New York Convention. I was impressed about the knowledge of Chinese judges regarding the New York Convention and also their intent to apply it correctly. So in certain cases, although there is some strategy as to choosing whether a foreign seat or a seat in China would be adequate, there are some cases in which, at least in the enforcement stage, you can rely that China will do its part and will fulfill its obligations under the New York Convention.
Thank you, Peretti. So now back to a topic Vanya briefly touched upon and which links perfectly with what we're discussing now, which are the so-called neutral seats. So in international contracts, it is common to speak of a neutral seat. In practice, what is the importance of a neutral seat, and could the virtualization of proceedings have impacted this vision? And before calling Bernard to answer that question, those questions, I would like to also pose Cesar Pereira's question here in the chat function. So taking the Shanghai Arbitration Commission as an example, 20% of its foreign-related caseload in 2021 were related to Latin America, usually involving Chinese companies' subsidiaries in Latin America. Do you think that in general, Chinese subsidiaries in Latin America would be open to use local or neutral seats within Latin America for cases like these? So without further ado, we're done.
Thank you, Luíza. I'll answer the questions in order. So first, with regards to the importance, the practical importance of a neutral seat. The first thing I would like to stress is the matter when choosing the seat, and particularly when trying to choose a neutral seat, we are heavily impacted by the devil we know conundrum, meaning that if we leave it to the last moment to discuss what would be the seat of the arbitration, it's fairly common for the parties or the council not to have the time to properly assess what are the proper or appropriate, let's say, seats for that dispute. Hence, they prefer to go safe and go for a neutral seat. And that seems to be the case that happened, that Vanya mentioned, when the Chinese party refused São Paulo outright as a seat and preferred to use Paris, even though, as Vanya mentioned, they could, for instance, if that would be a problem, put the seat in São Paulo and do the hearings at Paris with no problem. But moving to the question itself, and speaking of my perceptions, the practical importance of a neutral seat is most related to the neutrality of its courts. Parties perceive, not entirely without reason, that courts may look more favorably to local companies, especially when they are somehow connected to the government, thus giving somewhat of an edge to them whenever the courts of the city need to get involved. This concern is particularly relevant for the enforceability of the arbitration agreement, of interim measures, and of the future award. However, this also means that the importance of a neutral seat may not be overstated, although it may still play an important role depending on the jurisdictions involved. Once again, particularly when dealing with parties involved with local government, we do have a reasonable number of jurisdictions where the local courts are considered impartial, particularly coming from the last 2 decades. This being the case, neutrality may become a matter of less importance and may, as I previously addressed, be used mainly due to the fact that most of the time the seat of the arbitration is discussed at a later stage of negotiations. We also see from empirical research conducted mainly by Queen Mary and White and Case, that the familiarity with the legal framework and the legal culture is less and less considered relevant by the parties in the council when selecting a seat. And this may be explained by the fact that we are more and more into an interconnected world. And so we do have available counsel, arbitrators, they are familiar with different jurisdictions, which are more and more open to the international arbitrators, international law firms acting inside that jurisdiction. One final important aspect when deciding the seat that I would like to address, and is not mentioned as often, but was somewhat brought by Cesar in his question, is the availability of assets of each party in different jurisdictions. When discussing strategies for the negotiation of dispute resolution clauses, I have seen companies preferring to concede its home field advantage, let's say, and go to a neutral seat whenever they perceive that their assets are mainly located at their seat of business, and on the other hand, its commercial partner has no assets there, meaning that depending on the case, and despite the possibility of issuance of bonds and guarantees, as mentioned by Cesar, a party may prefer to use a neutral seat so that neither party is particularly vulnerable to an adverse award should the deal go south. Going now to the matter of virtualization, whether it should help other jurisdictions, other seats to be considered more often, I believe virtualization is impacting the choice of the seat, but not in the manner we might first expect, meaning that the idea that virtualization might remove borders and broaden the number of available seats is not entirely correct. for instance, we see that the location of people, arbitrators, counsel, and hearing facilities have all but vanished in recent years from the list of reasons given when selecting a seat. We can see this if we go through 2010, 2015, 2018, 2021 surveys conducted by Queen Mary. On the other hand, we see that other concerns have appeared. For instance, we see that in the 2021 survey, the ability of local courts to deal remotely with matters related to arbitration has risen tremendously in importance for parties and counsel. So, although it is not automatic that the virtualization will impact the more open availability of seats, countries may use this, let's say, obstacle as an opportunity to develop as an arbitration hub. For instance, Brazil may gain an advantage from this based on the fact that nearly all its court caseload has been dealt virtually for several years. And when the pandemic hit, despite some hiccups and growing pains, it was able to very quickly adapt to operate remotely, meaning both hearings, speaking with the judges, and so on and so on. And as addressed by Luíza Kömel at the beginning of her speech, CAM-CCBC is doing the same. It took the opportunity to accelerate a virtualization process that was already underway. And now we can say, at least from my practice, that in local hearings, hearings that are not virtual, is still the main way that hearings are being conducted. However, that being said, at the end of the day, the main factor considered by parties when selecting a seat has kept the same for decades now. It's not likely to change anytime soon, virtualization happening or not. And that is how the courts of the seat behave towards arbitration. Do they easily enforce arbitration agreements? Do they easily enforce awards? Do they support arbitral proceedings and enforce interim measures ordered by arbitrators? Are they neutral and impartial when dealing with local companies? Those are the main questions posed by counsel when selecting a seat. And thankfully, many regional hubs are coming into play in recent years, where all the questions I pose are answered in the affirmative. It comes to mind Singapore, Hong Kong, São Paulo, for instance, that are established themselves as regional and even global powerhouses. Now it is up for the courts and arbitration institution, as CAM-CCBC is doing, to keep up the good work from the decades past and use virtualization to its advantage instead of being an obstacle to continuous growth. As to the last question, would the Chinese companies' subsidiaries in Latin America be open to use local and neutral seat? I think as addressed, they still have somewhat, as mentioned by Vanya and by other speakers before me, they still have somewhat of let's say, prejudice against seats outside of Asia. However, I believe that virtualization may also open a door for new seats. Aside from São Paulo, for instance, Lima is establishing itself also as a regional, as a relevant regional hub, and maybe is perceived as such for disputes between Brazilian and Chinese companies, for instance. But I will leave to my colleagues that are much more experienced with the Chinese market to address this question more fully. Thank you.
Thank you, Bernard. Vanya, could you kindly share with us your experience or your perspective on this topic?
Sure, of course. Well, I agree with everything that Bernard just said. And I would like only to make some remarks here. Because I think that when a party makes the choice of the seat, this is, of course, we are talking here is a matter of great importance, because the law of the arbitral seat will govern several different legal issues, including, well, the national arbitration law applicable to the arbitration, the procedural law of arbitration. National courts will be responsible for analyzing actions to set aside arbitral award, and the national courts in the arbitration seat can have authority to appoint and remove arbitrators, grant provisional measures, resolve jurisdictional challenges, and in some cases even the law of the seat and the courts will have the power to decide if a claim is arbitrable or not. And apart from these legal issues, there are some practical issues that parties take into consideration when choosing a seat, which are the convenience and cost, so availability of hearing facilities, accommodation, transportation, technical support, time zone, logistic, and because normally in most of the cases, especially before pandemic, hearings were held in the arbitral seat, although it is perfectly possible and it has been to hold hearings outside the arbitral seat. So in my point of view, the virtualization of the proceedings will affect only what I've called the practical issues related to the choice of the seat, but won't impact the other so important consequences that arise from the choice of the seat. And neither party is concerned about having a neutral seat. I know that it's important to distinguish between the seat of arbitration and the geographic location where the hearings and meetings in the arbitration take place. The venue of the hearing and meetings is something totally different from the seat of arbitration. And most national laws, institutional arbitration rules allow hearings and meetings to be conducted in other places different from the seat for parties' convenience. But the same conclusion I said applies to virtualization of the proceedings, because in this case, parties won't have to worry about logistic, transportation, accommodation costs, and so on. These practical issues will be resolved, but the importance of a neutral seat to establish the law that will govern the arbitration proceeding and the law that will eventually decide a challenge to the arbitration award, these won't be modified by the virtualization of the proceeding. So that's my opinion. Thank you.
Thank you, Vanya. Last but not least, we have the very interesting topic of the clash of cultures. So I want to hear the speaker's take on this. And so let us start with Luiz Vidal. Have you ever experienced any issues regarding cultural differences between parties? And specifically in arbitration, do you think that international arbitration is beyond those types of issues?
Thanks, Luíza. Yes, between the parties, most definitely. But if the arbitration, international arbitration is beyond that, I would argue that depends. I'll try to answer both questions like simultaneously, and I guess it can be a good way to understand like why. Understanding like how to manage like these cultural differences, in my opinion, it's as important to do in an arbitration procedure as to conduct the business international transaction itself. There is a Dutch psychologist, it is called like Gert Hofstede. He developed a theory to compare different cultures, basically creating standards to facilitate such comparisons. So he created what they call like the 6 dimensions of the cultural mapping, and this includes like power distance, which measures how hierarchical the society is, individualism versus collectivism, masculinity versus femininity, uncertain avoidance, which is basically how society can bear uncertainty, long and short orientation, indulgency. These are the main parameters. And in this sense, when you engage with a party, both to negotiating like an arbitration agreement or actually entering in an arbitration procedure, or how to deal with also with the arbitrator, these factors, I mean, besides the standards and the rules, like is actually being conducted conducted by human beings, right? So it's the cultural background cannot be detached. And in this sense, for the arbitration procedures to be held, I have to quote what Peretti said, and was like also brought by Bernard in his last speech, is that using like a very international environment, international arbitration centers such as CAM-CCBC or Hong Kong International Arbitration Center, ICC, actually narrows down how these cultural influences can actually affect like the decision from an arbitrator, or how the parties actually can behave, right? In this sense, like if you take this study from Hofstede, like, and you compare, like, for example, Chinese and Brazilian societies, you will see that the Brazilian societies and Chinese are quite similar in the hierarchical like power index, power distance index, and on masculinity. So it's bear more or less similar characteristics, despite the Chinese society being highly hierarchical when compared to the Brazilian one. But on the other factors is that the society really goes apart, and these you can have a very different views what you can impair in contracts, such as like how uncertainty you can bear in such relationship, how long-term and short-term view can affect the procedure, or how indulgency can be a factor for like an enforcement of an obligation, etc. So just bringing to like a real case that I guess can enlighten a little bit what I'm trying to point out here. We had like during the pandemic, it was a Brazilian project, transmission line crossing Amazon, with very challenging procedure. It was hired before the pandemic struck, and everything was like delayed, suspended. And the project owner in Brazil was really concerned about the delivery date of the project and the fines that the regulator might impose, or the delay of other, because it's a transmission line. So other delays, these not delivered, could impact in the supply of the energy, which was already hired. From the Chinese perspective, they had to, it was an EPC, a listed price EPC, so they have to fulfill the delivery of the towers, the steering of the cables, supply the cables itself. But in the contract, there was no provision whether who should pay for the homologation of the cables before the Brazilian regulator. And in this sense, this became like a real debate, and was actually a pre-litigation stage already. Gladly for them, like the problem was actually resolved, and arbitration was not filed. But in this sense, the main point of discussion, basically, you could resolve, or it was resolved based on how the parties interpreted the clause that complied the Chinese side to deliver the cables. In this sense, they were actually complied to deliver the cables, which could be used in Brazil, and therefore duly homologated. But there was nothing saying in the contract that they actually had to pay for the certification or the homologation procedure, which can be quite time-consuming and expensive. So in this sense, the Brazilian side, which is a society that has a very little tolerance to uncertainty, was actually willing to go to arbitration to prove that this was not on the contract. And but it forgot the spirit of the contract itself, because since it was like in this case an EPC, price list is not a turnkey one. Such cost was not predicted, so it has to be reflected in the contract afterwards. So these cultural differences, I guess, impacts much more on the relationship between the parties and how the parties enforce and fulfill the contracts, but also can impair on the arbitration procedure, and then depends how international or how specialized or professional the arbitration center that is decided to be the seat can be can have such internationalization standards or not.
Thank you, Luiz. Sherlin, since you are the non-Brazilian speaker among us today, we cannot leave without hearing from you. So what are your thoughts on the clash of cultures?
The only downside or the upside, who knows, is that I am the American Taiwanese speaker. So I still got a little bit of West in me, but I will actually say, I agree that the two cultures are actually quite similar. I see it in my clients in China, also in Brazil. Maybe people aren't going to believe me, but the Chinese really are actually very friendly. They have this jovial attitude. They don't like to really mix business with pleasure at all times, or they do, but they spend 5-10 minutes on business, and the rest of the evening, if you're going out for dinner, is just a wonderful dinner with Mao Tai or some type of drinks, and they want you to feel at home. And I get this all the time with my Brazilian friends, because it's just a very safe and comfortable and happy environment. And actually, I guess as a lawyer, we have to be a bit thankful for that, because that means perhaps the transaction in itself or the contracts weren't as tight and precise as they need to be because of the jovial environment between the two sides. And when it comes time to the dispute, oftentimes you see a bit of a disaster. But I think, or at least from what I've seen, from what my experience, and that's why it's known as this midnight clause, right? Nobody really wants to talk what's going to happen to the dispute. They want to talk business, they want to talk successful business, and on top of that, they want to make this, a happy relationship. Perhaps you're not going to be the best of friends, but every time you see one another, you're happy to see. So I guess I don't really see much of a cultural clash in that respect.
Thank you so much, Sherlin. I think Cesar shared with us something in the chat, but I have not been able to read it yet. So last few words, does anyone wish to come forward? Peretti, do you have any anecdotes? Bernard, anything you want to share before we close this?
Just a quick comment, Luíza, if I may. Well, it's very interesting to hear Luiz Vidal's and Sherlin's perspective, since they are located in Asia. Sherlin, I know travels a lot, but it's interesting to see how that culture also pervades the functioning of the foreign controlled companies here in Brazil. I have had clients that were Brazilian subsidiaries of Japanese companies, and most of the decisions were taken with the influence of Tokyo, and also the same happened with Chinese clients, where you see that there is a Brazilian management that is closely connected with the parent company. So you see those cultural traits influencing the day-by-day activities of Brazilian companies in Brazil. It's an interesting topic. I love to hear their comments on this.
Thank you, Peretti. You would like to hear, excuse me, did you say you'd like to hear anyone in specific?
No, I was just complimenting and telling that this is a relevant issue in arbitrations, because the influence of cultural matters is real.
Okay, thank you. Okay, so since we at the CAM-CCBC are trying really hard to build a reputation for Brazilians being on time, let me go ahead and thank you everyone for speaking and for watching us today. We wish you all a great Vis East week, on behalf of the CAM-CCBC. Thank you so much.
Thanks, everyone. Bye-bye.
Thank you, everyone. Bye-bye. It was a pleasure.
Thank you. Bye-bye.
Thank you.